Right, I think we'll just make a start. And Sally will continue to let people in. Welcome everybody. My name is Ranald McTaggart. I'm the Deputy Director of the CYCJ, and I'm delighted to be chairing today's webinar on the age of criminal responsibility, exploring how the children's hearing system currently addresses the serious behaviour of children just above the ACR threshold. This is based on research, which has also formed the basis of a report which has been published by SCRA today, and the link to that will be in the chat. The webinar is going to be recorded and shared on the CYCJ website, and it will finish by 1 o'clock at the latest. Your cameras and mics will be switched off to all the attendees, so only the speakers and the organisers of the event will have their cameras on. So we'll hear from Christina, and then we'll have some time at the end for Q&A. So please type your questions into the chat function. You can do that at any stage of the webinar, and we'll try to respond to as many of them as possible by 1 o'clock. If there's questions that we haven't been able to respond to, then we'll do our best to just answer those in writing, kind of following today. So I'll just welcome our speaker for today then. So it's Christina Moody, who's probably known to many of you here today. She's a research officer with SCRA with a particular interest in children in conflict with the law. Christina has got more than 25 years experience in research, including 10 years as a research associate with the CYCJ. So it's lovely to have Christina back as a guest to one of our webinars. Great to see you, and we're just really looking forward to hearing more about your research. There's been huge interest in today's webinar, so it's also a topic that people are really keen to learn more about. So we're looking forward to hearing from you, Christina. So I'll just hand over to you now, and hopefully your slides will work for you.
Fingers crossed. Hi everyone. I've seen a lot of names that I know popping up in front of me, which is very distracting. Can you hear me, Ranald? Can you just confirm that I can still be heard? Brilliant. Yep. So this is a bit of an overview of a new report that we've finished in SCRA, SCRA. It was published yesterday lunchtime. I'm going to make the assumption that you haven't been able to read it between yesterday and today. So this is going to essentially give you a bit of an overview, but it's a chunky piece of work. So there's a lot more information actually within the report itself. So I would direct you to get yourself a large flask of coffee and go through that when you've got some time. But I'm going to explain, just to start off, a little bit about why we were doing this research and what we found. And as Randall said, there'll be a little bit of time at the end for questions. I hope to stop talking in enough time to give you that time at the end for questions. And obviously, if there is anything that we don't get to, if we run out of time completely, I'll be happy to address those by email. So I'm going to try and move my slides. So as you'll know, the Age of Criminal Responsibility Act in Scotland, it really changed the process for how we respond to children causing harm. So it commenced in 2021, and there was a duty on Scottish ministers to review the operation of that act with a view to considering any potential future age of criminal responsibility, and that was to happen after 3 years of the commencement of the act. So they're actually making that decision. The review from them is due December this year, which is next month, so no pressure. One of there was an Age of Criminal Responsibility Advisory Group set up as well, which looked at what was going on in terms of the data, and the 4 broad areas of interest that they had were looking at operational challenges, the potential impact on victims, concerns from the community, and thinking about the data and research findings. And that's really where this piece of work comes in. Now, prior to this project, there was a previous piece of work that was carried out by SCRA which did look at a large sample of children who'd been referred to the reporter rather, for offences aged 12 to 15 years. It was a large sample of children, 400 children were in that. They were referred on a J ground, wasn't necessarily a serious offence, but it was on a J ground for an offence. And that piece of work, which again was a hefty piece of work, it described the types of offences, but most importantly, the needs of the children and the backgrounds of the children who were referred on an offence ground. So this piece of work essentially bounced off from where that project ended, but it was looking more specifically at those offences that could be deemed serious. So again, we were looking at children aged 12 to 15 years, those who would fall within the age of criminal responsibility. Also wanted to look at potential gender differences. So we matched our samples in terms of numbers. And we also wanted to understand how reporters come to their decisions when a serious offence referral arrives with them. So because there's no commonly used definition of seriousness, we used a kind of proxy filter for seriousness, which has been used before by SCRA and the police and Social Work Scotland, I think, as well. So it was based on the Section 39 of the Age of Criminal Responsibility Act. And that's the kind of test that we used. So essentially, they fell within the sample of serious offending if they behaved in a violent or dangerous way, or by behaving in a violent or dangerous way, the child has caused or risked causing serious physical harm to another person, or by behaving in a sexually violent or sexually coercive way, the child has caused or risked causing harm, whether physical or not, to another person. Also falling within, so those are the broad violent and sexual offences, but it also included some dangerous driving offences, use of weapons and things like that. So the aim of the project was specifically, as I said, designed to look at serious offences, potentially any gender differences, as well as how the reporters make those decisions. These were the research questions that we were aiming to answer. I'll just let you rather than read them out, they are all there. Essentially, we were interested in trends, we're interested in factors that are associated with serious offending, patterns, the responses of statutory agencies, including Children's Reporter, and we also wanted to really think about public confidence as well. So we'll start off by looking at 3 years of offence referrals. So this really sets the scene, gets a picture of what's happening in terms of serious offence referrals to the reporter over a 3-year period. So this trends analysis captured data on all children referred to SCRA for that serious offence. So that was using that Section 39 test I just described. So between 2021 and 2024, and it provides an insight into the type and number of offences that would be dealt with by SCRA on offence grounds if the ACR was raised to 16 years. So 4.3% of all of the offence charges that were received during that 3-year period would meet that definition of seriousness. So we are talking about a very specific subsample within the usual offence referrals. That relates to 788 children. As you can see, far fewer girls than boys charged with serious offence behaviours. The majority of these were sexual offences, so that was 70%. The remainder were non-sexual crimes of violence, and there was some roads, railways offences within that as well. In terms of the charges for those kind of really the ones that make you think, gosh, that is serious, are the attempted murders, allegations of rape, sexual assault by penetration. These were very rare. So those accounted for 0.03% and 0.6% of the serious offences, respectively. So that's within this 3 years. So in terms of the number of offences, so I mean, we know boys are more likely than girls to be referred for an offence anyway, and that holds true when we're considering referrals for serious offences. The ratio of boys to girls is around 8.5 to 1.5, 9 to 1 roughly. And that's much higher than the 3 to 1 ratio that you find within offence referrals and official statistics that we've been able to glean. So these of serious offence referrals, the boys are falling within that. And in terms of the types of offence classification, so thinking about the different offence classifications and looking at the gender split within that, Boys more likely than girls to be referred for serious sexual offences, and girls more likely to be referred for non-sexual crimes of violence. The non-sexual crimes of violence, that includes offences such as assaults, robberies, weapons offences. And just a reminder, the person doesn't have to be physically harmed for a charge to be brought. The miscellaneous crimes, because I know people will question, that involves things like use of weapons and lasers, fall within that. There's not very many. The age at the serious offence referral. So again, this is really a pattern we'd expect to see with children more likely to be referred for an offence when they're a bit older. Pattern is roughly the same between girls and boys, perhaps a few more girls at the younger age there at the age of 12 compared with boys. And we'll have a look at one potential reason for why that might be the case a bit later on. But this is the kind of graph you'd sort of expect to see, I think. So that really was a very quick dance over, and I spoke very fast, so I'm going to try and slow down a little bit. That was a very quick dance over the kind of trends analysis that sort of sets the scene of the kind of pattern of referrals to the children's hearing system. So moving away from that kind of broader trend and back onto the research sample that we included in the study. So what we were looking at was a 9-month period, and the reason we chose 9 months was because we really wanted to match the girls to the boys in terms of number, and it took 9 months to be able to get a matching number of girls, essentially. So it was 9 months, randomly selected, although it ended up being essentially all of the girls. Excuse me, my phone is ringing. I'm going to just turn that off. Go away, right. So what this slide essentially shows is the full 9 months of referrals and the types of offence referrals, or the index offence that was the main offence that would have got them into our sample that fell within the serious offence, and compared with the case sample. So it kind of shows that it's broadly representative of all the referrals over that 9-month period. General pattern of boys mostly being referred to the reporter for sexual offences, although it did skew slightly more in the randomly selected sample, and it's most common for girls to be referred for non-sexual crimes of violence. And again, I'll talk about that a bit more later on. Oops. So the pathways to the referral. So this is, again, we're talking about the research sample. The majority of the offences that met that Section 39 test were jointly reported cases. 73% of the boys, 83% of the girls. The remaining offences in the sample were standard offence referrals, so they were solely referred to the reporter and not to the Procurator Fiscal at the same time. And those included different types of offences. So the SOSA, that's a Sexual Offences Scotland Act, so that's an assault by penetration. Assault by penetration of a child under 13, and sexual communication offences are listed there. Also, assault to severe injury fell within those solely reported offences as well. So other than the sheer quantity of the serious offence referrals, there's a gender difference in how long it takes for a final decision to be made in the case of the boys compared with the girls. So it's taking a lot longer for the final decision to be made when it comes to the reporter and they make that decision. And that's likely due to the fact that the boys are more often being referred for sexual assaults, which can be really complex in terms of evidence gathering. In terms of looking at the time it took from the date of incident to the date of decision, we were limited in that kind of initial information, the incident date and the decision date, because of the way our data is recorded. But we can see that quite a lot, although there's a big difference between the girls and the boys, there's a lot that goes on during that process when it comes to the decision making, between the witness statements, forensics, as I mentioned, and that holds true for both violent and sexual offences. In terms of, and I'll talk about this a bit more later on, but in terms of the delays, so obviously delays are not something that anybody wants to see when we're talking about children, because that's can be a long time in the life of a child. Reporters did identify that delays in them getting the case after the incident had happened can really affect whether the necessity test for a compulsory supervision order will be met, because the circumstances underpinning the behaviour of that child may have changed quite a lot by the time they get to make their decision, by the time they're investigating it. Or indeed, because the child's been engaging really well following the initial incident, there may not be considered to be a need for compulsion. So a lot of things are going on. It's not static between that time. A lot is happening in the life of the child. I'm going to just leave that one a little bit and move on to the next one. So in terms of thinking about the age of the children in our sample, so due to the small numbers, the tables had the ages aggregated. But what it does show, and the boys are in blue, the girls are in orange, is that the referrals for sexual communication offences were more likely to be received at age 12 to 13 than age 14 to 16 for girls. The sexual communication offences were relatively high among girls compared with boys. And the age at which the girls were being referred was disproportionately at a younger age than slightly older. And there was no difference between the boys, which is quite interesting. I'm not entirely sure why that's the case. I'm sort of speculating as to why that pattern would be happening, while also caveating these are small numbers. So we only had 30 in the sample boys, 30 girls. So these are small numbers. It doesn't take a lot for the percentages to go quite to look quite large, the differences. But this was something that was also mentioned a lot by reporters as well. So there could be something about maturity. There could be something about the age at which children are getting mobile phones. It could be something about just, yeah, I think there is something to unpick there about understanding of the law, about boundaries, and about what you are able or not able to do with a mobile phone. But that's worth coming back to. In terms of whether or not the girls or the boys are presenting with the same offences, again, the difference is the sheer number. Boys coming to police attention much more frequently, referred in much greater numbers. When interviewed, most of the reporters felt that although they did see serious offences from the girls, more rarely than the boys, those could be equally as serious, equally as concerning. One of the quotes from the reporter on the screen is, the difference I tend to see with girls is self-harm. Quite often with the girls, it's that kind of added element that they might not be violently offending in their communities, but that doesn't say it doesn't happen. That's not to say it doesn't happen. I had a child of 13 who'd assaulted somebody to injury. And another said, more often than not, it is boys. That's not to say there are no girls, but when the girls are reported or referred for serious offences, it's very serious. So, as mentioned before, girls in our case sample were more likely than boys to have an index offence that was related to violence, 62% versus 27%. In contrast, boys were more likely than girls to have an index offence that related to a sexual offence. Boys are more likely than girls to have an index offence related to dangerous driving. For the boys, the violent offences tended to all be serious assaults, but within the girls, there was a variation of serious assaults to assaults. Girls were also more likely to be involved in group incidents rather than on their own. When it comes to the sexual assaults, or the sexual offences rather, boys were more likely than girls to be referred for an index offence relating to sexual assault or rape, while girls were more likely than boys to be referred for sexual communication offences. So that was 45% of the sexual offences among the girls were for sexual communication offences. It's also worth mentioning that a number of the girls who were referred for sexual offences, that there was a couple of girls in our sample, and they were involved in assaulting members of the public one night under the influence of alcohol. So those were the types of sexual assaults that were showing up among the girls. So in terms of the backgrounds of children, this project, again, very much echoed the findings of the previous research that was carried out by SCRA that I mentioned at the beginning, in terms of documenting both by going through the case analysis of our sample and going through all of the social work reports and all of the data that we hold on the children, but also the views of the reporters, which was something that was additional in this report. So some of the quotes from the reporters are included here. There's obviously a great deal more information held within the full report itself. I would say that most of the children who are referred for serious offences either have adverse childhood experiences or they have some kind of diagnosed or undiagnosed neurodiversity. At times you can look at these teenagers and think this is the inevitable consequence of your childhood. The vast majority of children and young people who commit a serious offence have a background of other issues, whether it's trauma, neglect, or whatever it is. The cases where there are often nothing are the ones that are more likely to be sexual offences. If the offence has been referred to us by the fiscal and we've requested reports and assessments, they've come back and there's nothing in that child's background to explain why they would have demonstrated that behaviour. There's no ACEs or anything. They've got supportive parents, nothing obvious that would have led to the sexual offending. I'm not going to spend a lot of time going over the background histories of the children referred for serious offences. It's fairly well documented already. It is all within the report itself. But this was quite interesting, so I thought I'd include it. So one way to look at the backgrounds of children who have been referred to the report is to look at where their home address falls within the index of deprivation. And these are shown split by gender. To clean it up a little bit and to make it a bit clearer, I've only included the violent and sexual categories. The remaining offence types, such as the driving offences, much lower numbers. So we've skimmed those off for the time being just to kind of look at this. What this does show is that the vast majority of violent offences by the boys were within that highest quintile of deprivation, while the sexual offences seem to be a little bit more evenly distributed. Within the girls, again, you see the violent offence referrals. Many of the girls, again, are in that highest quintile. But across the other quintiles, the girls are coming from various areas of relative deprivation for both sexual and violent offences. What's interesting is looking at the sexual violent referrals, you see quite a few girls from the lower quintiles. We know from looking at the earlier slides that quite a lot of those sexual offences related to the sexual communication offences, 45% of them among the girls. So I'm wondering, so that does sort of change the pattern just a little bit. And in terms of the backgrounds of the children, moving on from that kind of area level deprivation that's captured within that deprivation measure, as described in previous research, most of the children in the sample do come from that background of trauma, adverse childhood experiences, high parental needs. This kind of information was collated from the file data that's held, social work reports, and reports like that. And more details on the backgrounds of the children are included within the report, but these are kind of the sort of things that were coming out in terms of disrupted schooling, in terms of loss and bereavement, which we would know disproportionately impacts these children, traumatic experiences, particularly parental needs, mental health, addiction, lack of stability, chaotic lifestyles. In terms of where they're living, the majority of the children in our sample were living with their parent or parents. Around a quarter were living out with their birth family. Another way to capture the needs of the children in the sample was to see to what extent the children referred for a serious offence were already known to social work or the children's hearing system. So this slide essentially summarises that. So 64% of our sample had a previous history of social work involvement. 42% had previously been referred to SCRA on offence grounds. 56% had been previously referred on non-offence grounds, and this was more common for boys than for girls, 72% versus 40%. 36% had previously been placed on compulsory supervision order, and that was more common for girls than for boys. and 24% were already on a compulsory supervision order when the serious offence occurred. 31% of the children referred for a serious offence were not known to either social work or SCRA. So we're quite interested in the age of that first system contact. This is essentially a U-shaped graph. They're always interesting, so we have to include that. So essentially what this graph shows is the first time the child was referred to the reporter on any grounds. So that could be for care and protection and or for offence grounds or other needs. So you can see for our sample, the peaks are very early years for care and protection grounds, and then not a huge amount going on, radio silence. And then when they're hitting age 12 and up, we begin to see new children coming in. And of course, that coincides with the current age of criminal responsibility. So there's very few kind of referred for that first time between the ages of 3 to 4 up to sort of age 10 to 11. So because we were looking at the case files for the children who'd been referred for a serious offence, we knew a little bit about the victims of various offence referrals within our sample. From this, we can see the majority of the victims were described as being peers of the child. I mean, the main thing is the sheer number of children who were offences, who were victims rather of the serious offence. So 63% were described as being peers of the child, children that the child knew from school or from the community. Further, 16% were described as having been in a relationship with the accused child. Again, when we look at the adults, there's far fewer adult victims. There's a disproportionate number, this 12%, with no previous relationship. So that really relates to the group of girls that I was referring to earlier who were all charged with sexual offences on strangers. They were acting as a group in one night. They were and it was unwanted sexual harassment incidents in a public place. So that is where that sort of 12% sits there. But in the sample, almost all the victims were known to the child, and the vast majority were other children. So when we're thinking about reporter decisions, these were the decisions made for our sample, both for the 9 months of referrals and also our randomly selected case sample, to kind of indicate again that it's broadly representative of all the referrals. I suppose what might strike you as interesting is how rarely a hearing is deemed necessary, and how rarely compulsory measures are deemed necessary. And the next slides go on to explain the way that the reporter is evaluating all of the evidence and coming to their decision. But there are several quotes from reporters that indicate that the ideal outcome for them is the child and the child's family responding appropriately to the incident, being open and willing to work with social work. As one said, if it's already happening on a voluntary basis, you say to yourself, well, there's the no order principle. So, why would I do that? Meaning, why would I ask for compulsory supervision? And of course, there will always be circumstances where you have to because they don't engage, but it's quite rare. Another said, the decision-making framework obviously is useful, but it would invariably come down to the assessment of harm and risk and the willingness or otherwise of the parents to engage with the services. Because like I say, why would you bring your child to a hearing to achieve something that's already been achieved by you and the mother? So you come back to that at every point. It's like, the decision-making framework is one thing, but then again, it comes to that. Is there a need for compulsion here? Do you know what I mean? So how do the reporters come to the decisions? So I interviewed 10 reporters and they spent a long time. I had lots of questions, very thoughtful responses. They talked me through their process of decision making, their interactions with other partner organisations, their focus when it comes to investigating the case in terms of the evidence and proof, while also looking at the context, not just around the incident, but around the child overall. So this slide is quite a packed slide. It reflects the various considerations that they're balancing in each of the cases. More detail of this and more explanation of what this all means is in the report, and including descriptions of cases where these all have come into play. So they described their use of the decision-making framework, which I mentioned previously, which they all found useful in structuring their investigation and their work. But these headings sort of show the various stages when a child has been jointly reported. So that that first column there, PF decisions, that's where the child has been jointly reported. And the communication and the way that the reporter will provide information where they have it to the procurator fiscal to help make that decision. But when it comes to the decision making, it reflects the Lord Advocate guidelines. They're balancing public interest versus criminalisation of children. They're evidencing the needs of the children who have been referred for an offence. They're evidencing interventions to prevent reoffending. Again, there was some reference to timescales and the length of time it can take for a decision to be reached. Delays are not anything that people want, but sometimes there are practical reasons why those types of offences within this sample in particular might take longer to investigate. As I mentioned previously, in terms of forensics, in terms of victims, there's a lot to go into that decision, particularly for PF. Reporters did describe situations where they were maybe being asked what would happen with certain children if the procurator fiscal were to pass that case to the reporter, and that's not something a reporter can answer prior to any investigation, and it sits with the children's panel anyway. And they did describe the sort of the way that the procurator fiscal and the children's hearing system have similar aims, but that the position of the reporter is much more solution focused. As one reporter described, I think generally the children's hearing system is quite solution focused. We've got the circumstances here. What's the solution to make this better? And can we involve the child and family in finding that solution? And another said, we always have to remember our system is an opportunity. Even if we bring somebody in on a J ground, an offence ground, it's not about criminalising them. It's about bringing them into the children's hearing system to give them the care and the protection that they need. So that's really the overview of what is umbrella-ing, that's not a proper word, but you know what I mean, all of this part of their decision making. So in terms of re-referrals, so we looked at our sample, we followed whether or not they had been referred again to the children's hearing system in the following 12 months. So for the majority of the children in our sample, they weren't referred to the reporter for an additional offence within the 12-month period, that's 66%. Of those who were referred again, the majority were boys, 70% boys, 30% girls, 34% of them all. The mean number of offence referrals during that 12-month period was 9 for the boys, a range of 1 to 36, and 3 for the girls, range of 1 to 7. Of that number who were referred within 12 months of the index offence, the majority were joint referrals. But the nature of those further offences tended to be of a lower gravity than the index offence. The range of offences that they were being referred for included vandalism, fire raising, possession of weapons, assault, including assault of a police officer, threatening and abusive behaviour. So there's a whole range, but they did tend to fall within, they wouldn't have fallen, the vast majority of them would not have fallen within the serious offence proxy filter that we were using. One boy was referred for an alleged sexual offence in the 12-month follow-up period, but it turned out that that was a historical incident that was reported later, so it had occurred prior to the index offence, but no other children who were referred for a sexual offence to the reporter went on to be referred to the reporter for a further sexual offence within that 12-month period. So the children's hearing system is, of course, a system with multiple parts, of which the reporter only plays one part. So it's important that each part of that system works effectively, and the role of other organisations is vital. So when we're thinking about engaging with the child, that part is so crucial, whether it's on a voluntary or a compulsory basis. Some reporters did express concerns around the extent to which interventions that were put in place to provide support were managing to engage with children who were coming to police contact again, or coming to police again. So this is because they're obviously seeing, if a child comes back again, they do see them, so they do tend to stick in mind. But for around half of the children of our sample, so just specifically looking at those children who were referred again within that 12-month follow-up period, social work reports did indicate that there were concerns around engagement, but what tended to be the case was those were mixed levels of engagement rather than none at all. So there could be they could be improving their relationships with their family, but they're still not attending school, or that they are not engaging very well with social work to talk about the particular offence, but they're actually not hanging around with the same group of friends that they had been getting into trouble with previously. So there was a kind of, it's not a straightforward, and you'd expect that because obviously desistance is a journey, and you would expect that these things aren't necessarily going to stop immediately that a referral is made. A large number of the children, as we've already described, they do come from chaotic homes, and some might be experiencing exploitation as well. So there's a lot to unpick there. It's also worth noting that we don't know how well engagement worked with different interventions when there wasn't a further offence referral. We could only see what happened for those children where they were referred to the reporter again. For those who do repeatedly come into contact with the police, those are the concern. Those are the ones that cause everyone concern and anxiety. In terms of the reporters talking about the children that they see, one said that their experience is that the children who are repeat offending and those who are committing a serious offence are sort of separate. They said you will have young people who are persistently offending low-level offences, breach of the peace, vandalism, minor assaults, antisocial behaviour. Another said assault to severe injury or sexual offence. I would say that they're more likely to not follow somebody who's persistently offended. Not always, but I would say that there's kind of two kinds of paths there. So that is obviously an issue that reporters highlighted as a real challenge for them within the children's hearing system. Those children who engage in repeat offending with suspicions of exploitation in particular, children who are engaged in non-serious repeat offending, and children who already commit a serious offence and continue to, although those numbers did seem to be low. Children who were already subject to a compulsory supervision order were identified as a group where that engagement could be particularly poor. There were some examples that reporters described children in that situation considering themselves as untouchable. For those where there is repeat offending, reporters highlighted the need for earlier interventions when there are changes in behaviour. So that could be through the drafting of new grounds by the reporter or through social work calling an early review. Reporters were keen that where there isn't any progress happening or where lack of engagement is a concern, that a review should be called by social work. And a few of the social reporters felt that that wasn't necessarily the case, and they wouldn't see that child again until another offence referral had come in, and then they would see that there had been concerns throughout that period, and they were frustrated that they hadn't been able to perhaps look at the whole picture. Addressing the behaviours of this particular group who are not engaging can be really challenging, where there's little engagement, where there's an inability to recognise that behaviour is wrong, or where there's exploitation happening as well, and then a blanket denial that is going on. So harking back to the importance of skilled and supported workforce around the child, reporters spoke really highly of the work that particularly dedicated youth justice teams do with children. There was concerns raised, however, that not every area across the country has access to that same resource. Resource issues were mentioned again by reporters in relation to the importance of appropriate risk assessments in a timely manner, because reporters really rely on that during their decision making, and there was sometimes a concern that they were having to chase those up, or they were having to request them specifically, and there may not be somebody within that office who was trained to complete those type of risk assessments. And that could really impact the identification and the delivery of interventions for children. We were also interested in the public's perception of the children's hearing system. So we asked the reporters kind of what they felt, particularly when it comes to the experience of victims when the case is dealt with through the children's hearing system. One quote here from a reporter: "I don't think the public out there understand that to provide support to a young person whose behaviour is going off the rails has got a far better chance of them not doing it to anyone else, which is surely, as a society, our number one goal, not just for future victims, but for the person, for the offender." The perception was that confidence in the hearing system really relies on seeing that that behaviour has changed. And what we can see in our sample is for the majority that is the case. The behaviour does change, at least in the short term that we followed up on. But it's those high profile cases that the repeat offences, those repeat series offences, that can really undermine that when it comes to the public view. Reporters specifically highlighted the victims' experiences, particularly in relation to sexual offending, as being a real potential barrier to public confidence in the children's hearing system, that it's just not being taken seriously, perhaps. And again, that's kind of coming to police attention again. So the key issues that came out of the reports included this lack of awareness among the public about what the children's hearing system is aiming to do. The challenges of evidencing sexual offences, which is true where in the children's hearing system as well as within courts. The impact of court upon vulnerable witnesses, how that can affect the ability to evidence the offence. Information provided to victims, we know that's been a long-running concern, that there's a limited amount of information that can be shared with victims once the offence comes into the children's hearing system. And that can sort of fuel a feeling of injustice within victims when there appears to be no consequences for the child who is harmed, because they don't know what the consequences are and they don't understand what's going on. So I'm going to, essentially, this is the summary. I know I've spoken incredibly quickly and covered quite a lot of ground. I would recommend reading the full report. It's written in a much less fast manner. So the majority of the children referred for a serious offence have experienced trauma and adversity. However, there are a group of young people referred particularly for sexual offences who will not have previously been known to services. Reporters are raising concerns around knowledge of consent that we saw replicated within that case file analysis. So beyond the youth justice response, there's implications for sexual health, parenting, relationship education. Obviously, this is something that we really need to see happening. There were some gender differences in decision making for boys and girls, and not about the decisions necessarily around compulsion or around hearings, but in the delay that it takes to reach a decision, which might reflect some of the severity and the nature of offences, because the boys were more often referred for sexual assaults. And that has implications for the ability of services to respond appropriately and quickly to the children's needs. As I mentioned earlier, a lot can happen in that time that it takes between the incident itself and the final decision being made. So very few serious offences referred to the reporter resulted in a hearing being scheduled. And that really comes down to that changing context for the child. Good risk assessments when they come in, they're very appreciated, appropriate care planning, and the levels of support that the children received all contributed to the decision not to schedule a hearing. In most cases, existing measures, referral to the local authority, were seen as the most appropriate response. A referral for a serious offence does not mean the child is likely necessarily to offend again. 2/3 of the children referred for a serious offence did not have another offence referral within 12 months of being referred. And those who did, it tended to be of a lower gravity and not fall within that serious offence measure. None of the children referred for a sexual offence were referred for further sexual offence during that 12-month period, referred to the reporter, that is. We wouldn't know if they were referred only to the Procurator Fiscal, but it would come to us as well. A small number of children do continue to engage in offending behaviour and do not engage well with the supports put in place to reduce offending. That was within our sample of 59, that was less than 5 children did not engage at all, and that was coming through the social work reports. And there were some concerns among reporters that some children who offend while already on compulsory supervision orders view themselves as being untouchable because of that. These repeat offence referrals, along with the victim experiences, have the potential to undermine public confidence in the children's hearing system. So we really need to improve public awareness of what the hearing system is aiming to do, what it manages to do well, and where its successes are. And the social work service inputs around children who offend are extremely valued by reporters. Our results indicate they do make a massive difference, but concerns exist about resourcing, about regional variations of resources, of the support for the workforce and the training and knowledge, which isn't always the same. If the ACR, if the age of criminal responsibility is raised, we would probably argue that it should be, needs to be underscored by further investment, is kind of our takeaway point. We were left with some questions to ponder, and you'll probably all have lots of questions as well. But these were some of ours. There was a lovely quote by Susan McVie, who said, "The evidence around using harsher punishments as a deterrent frankly does not stack up. We should be reassured that Scotland has the structures and mechanisms in place to deal with such incidents in a sensitive, holistic and trauma-informed way. However, whether it has the capacity and resource to do it is another matter." And I think that is worth echoing. We know that children coming into conflict with the law, the numbers are reducing. Do we have the capacity and funding to support those children that do, and their needs, particularly the complexity of their backgrounds? Do you think that the evidence supports an increase in the age of criminal responsibility? Are we doing enough to support the identification of children who are being exploited? How do we address these sexual communications offences among children that were particularly apparent among girls? And how do we better explain our welfare-based approach to the public to bring them with us, essentially? So that's the end. I feel like I've been talking quite a lot.
Thank you, Christina. That was fantastic. Yeah, just triggering lots of questions and thoughts in my mind, I suppose. Oh, no, I'm not. I think, can you hear me?
Sorry.
Yeah.
No, I had it.
Yes, you can hear me. Yeah, okay. Yeah, just I suppose some things that came to my mind were, the third of the children that aren't known prior to a serious offence, and yet virtually no children referred to the report are between the age of 3 and 11. So you kind of wonder, are we missing some early warning signals? Concerns around some of the younger children who then go on to be involved in serious harm, and given the number of victims that are known to children, you do wonder what the role of restorative practice, restorative justice could be as a key way of building public confidence, in terms of victims actually seeing or being able to participate in a process which allows them to maybe get some resolution to the harm that they've experienced. And yeah, I suppose, yeah, just how do we get the message across that how few children actually repeat serious offending? You know, tiny numbers. How do we get those messages out? So yeah, just fantastic input there. So
just what you
we
were
have three
saying
questions.
about that, just to jump, just what you were saying about that kind of that U-shaped graph that I showed, that kind of the early, so children coming to being referred usually, well, of course, on care and protection grounds at that kind of early stage. Reporters were talking about then not seeing those. So not only, but those ones were then not being seen again until hitting their teenage years, and then it all kind of beginning to be tricky for them then. And I think that's really interesting as well, that you could have a little bit of support put in place pre-birth around that kind of really early stage, and then not really see a lot, and then they come back when they're 14, 15 with when it's all kind of gone really wrong for them, and it's a serious offence. So there was, I mean, the report is interesting in the sense it does capture, I hope, quite a lot of just the individual. We've got lots of case studies in the report as well, which really kind of highlight the different ways that children are coming into the system and being referred to the reporter for a serious offence, and it's not what people would automatically think a lot of the time, which I think is really interesting.
Yeah, great. Okay, so we have 3 questions in the chat. First one is from David. You might not be in a position to fully answer it, but he was just asking whether, you know, in the last 20, 25 years, we are seeing a downward trend in serious offences by this age group.
I would have to double check. I suspect yes.
I would imagine so, because I think all the stats do suggest that there's a general downward trend in all offending, including by children, which would assume would include serious offending. Yeah.
But it's an interesting point. I will see if we can. I'm sure there will be some data on that, so I'll have a look. But I'm going to assume yes.
Yes. Yeah.
Sorry, David.
And Laura has asked a very specific question, I think, in relation to the joint reporting slide about the delays. So it was just an extremely specific question about whether that's days or working days.
It was working days.
Working days, brilliant. That was easy. And then Ross asking a question about the preponderance of girls being involved in sexual communication type offences. I'm wondering whether that features quite a lot of girls sharing images of themselves, which are then shared, and then ultimately the girl is then charged. Was that something that was featuring quite a lot, do you think?
With the communication offences, the originator of the image, if it was of themselves, those weren't the ones that we were seeing. So we didn't have any examples of that within but we could have got the in between. We could have got the person in between. So the person who's getting an image from their partner, say, and then forwards it on to friends, to peers, and they're bouncing that on with them without necessarily realizing what they've done, that they've not only, and there's cases, there's a case study that's described in the report where that essentially has kind of happened with a group of children, where a girl has received an image. It was actually a different form of media, and forwarded it on to someone else, a friend, group of friends, and she ended up picking up 3 different sexual offences. So it was having it on her phone. It was coercing somebody under the age of 13 to view it. And the third one I'm completely blanking on, but there ended up being 3 different offences within that. And that was, she hadn't created it herself, but had shared it on. Now, in that situation, fortunately, the case came to the reporter, and the parents had responded appropriately, with shock and horror. The child had responded, not really realising what she'd done wrong with huge remorse. And because it all happened within one school, the school took steps to do a lot of work around the appropriateness of using sharing images and that kind of thing, and basic respect and boundaries and not using mobile phones for that kind of thing. But again, that child would have then had the stress and anxiety of that period of time waiting for that decision to happen. So yeah, there was a lot of that, a lot of what you'd consider teenage boundary pushing behaviour, but with a victim as well.
Yeah. Great. So there's a question from Kathy Grant, which I think is really a question around the grounds, the issue of grounds. So, you know, she's talking about young people whose behaviours may be driven by mental health, substance misuse through, you know, self-medicating, but then coming into conflict with the law, police detention. So yeah, I suppose just raising the concerns about what grounds these matters are then dealt with under. You know, are they always offence grounds, or do the reporters consider more welfare grounds when there's these kind of drivers behind the behaviour? I'm not sure if you have any kind of thoughts on that one, Christina.
Yeah, I mean, I suppose the referral will come in as an offence ground. It will come in as a J ground, but what we've seen with our numbers, when it comes to the decision of the reporter, there's very, very few hearings. So in that sense, the response is going to be very much around responding to their needs that led to that harmful behaviour.
Yeah. And I think just in relation to exploitation, you know, I think we should be reassured that, you know, reporters are very alive to that issue now and are, you know, where they do have those concerns or do kind of spot those risk factors, that they are very keen to make sure that the young person is not being responded to primarily as an offender, but as a potential victim of exploitation. But I think we're all still at the fairly early stages of that journey in kind of really understanding criminal exploitation and the complexities around that issue. But
yeah, it is very, very tricky, as we all know. The Procurator Fiscal are also very, very alive to trying to explore if this behaviour is stemming from exploitation. We had a small number within our sample where they were at risk, they were being exploited or were at risk of being exploited. And it is very, very difficult where the child denies it, perhaps even where the family might deny it. There's a lot of fear, there's a lot of anxiety, and so evidencing it is just really, really tricky.
Yeah. Great. Okay, that's 1 o'clock, so we probably need to draw things to conclusion. There was one final question. Well, there was a question about sharing of the slides, and I think we'll be doing that. So
Yep.
Task. Do that.
Okay, great. Yeah, we'll do that.
No problem.
Great. So yeah, so thanks. Thanks, Christina. That was fantastic. Really thought-provoking input there, and it's given us a real taster for looking at the full report. So I do encourage folk to, when you can, have a look at the full report that's been published today. If you're not already signed up to our e-bulletin, then there's links in the chat for that. We're also promoting our new e-learning platform, and we're launching roughly a new module each month. So please explore that. And there'll be links in the chat to upcoming webinars and also our stakeholder and website surveys as well. We're encouraging folk to complete as well. So thanks everybody for coming today. It's been a really good turnout and really interesting discussion and input. So yeah, thanks for taking part, and enjoy the rest of your day. Cheerio.
Thanks for having me. Bye.